We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. Welcome to the Appeals Court, where, due to the ongoing pandemic, we are holding oral argument by video conference. The rules are the same as they are when we meet in person at the courthouse, which is to say 15 minutes per side and no rebuttal. I am Judge Rubin, I should have said, and I'm joined today by Judges Wolohojian and Blake. The first and actually only case we will hear this morning is number 20-1310, Commonwealth versus PLOUDE, and we will hear first from Attorney Athanasu.
Thank you. Good morning, Your Honors, and may it please the Court. Nicholas Athanasio on behalf of Mr. PLOUDE, who I believe is watching us today. Your Honors, we're here today because the judge who denied the motion to suppress identification in this case essentially ignored the tattooed elephant in the room. That Mr. PLOUDE was subjected to an unconstitutionally suggestive photo array identification procedure in two respects. First, and most importantly, Mr. PLOUDE was the only person with visible neck tattoos in a photo array that was shown to an eyewitness who had been assaulted by a stranger with neck tattoos. And second, the officer, before that array was shown to this eyewitness, communicated information about the investigation, that the perpetrator's cell phone had been left behind, and that police believe.
Ask you about the photo array at Record Appendix 49, Volume 1. That's the photo of your client that was used in the photo array, correct?
That is.
And so if you're looking at him, you can see some marking on the left and right side, sort of back behind his ears. Is that right?
It looks like it's the side of his neck on both sides. It looks like there's some sort of.
And then if you go to R57, is that your client currently?
That is correct.
And so what I'm seeing, I guess, under his chin and in the front of his, above his t-shirt opening, that picture was not in the photo array.
That is correct.
Okay.
That was the picture of his booking photo from when he was arrested the day after the alleged incident. The photo array photograph was an older photograph.
So did the officers have what's at R57 available to them at the time that they put the array together, or did they only have R49 available as far as you know?
They did not have R57. R57 was photographed the day after the photo array procedure. So I don't know if they had any other additional photographs. All I know is at the time they used the photograph in R49.
Is your argument that the officers must use a photograph that matches the description in all respects?
Well, not necessarily, because the warnings, the Silva Santiago warnings say that there can be some change in appearance. The problem here is that the neck tattoos didn't need to be part of this. This, essentially photo array identifications are tests of memory. And the most accurate way to ensure that a test yields accurate results.
Can we just go back to my question?
Sure.
Mostly it's just so that we don't get too far off from what's bothering me in the case. So if the photograph doesn't need to match the description in all respects, what's the line between, what do our cases say is the line between how far off from the description the photo can be?
I don't think Article 12 requires perfection or exact, replication or facsimile. But the problem here is.
Okay, so I have a whole series of questions. So So if it's not perfection, if it's not a perfect match, what does it need to be in order to pass constitutional muster?
I would say it needs to make sure that the suspect, that the police believe is a suspect, does not unfairly stand out. And I think here,
Unfairly what?
unfairly
Singled up.
stand out in the array.
Stand
And that's
out.
something.
Okay, so that's a different answer, because I asked vis-a-vis the description from of the perpetrator, and you've now switched it to a comparison with the other people, which may be perfectly legitimate, but I actually was trying to take it step by step, which is against the description of the perpetrator. So if the description of the perpetrator says, you know, person this high, this whatever, series of things, and the person is clean shaven, and the photo array includes someone the police think for other reasons is a suspect, but the only picture they have shows him without a beard. Can they use that picture?
I believe they can. Because again, we're not talking.
And if it shows him with a beard, can they use that picture? In other words, if it, and I forget what my hypo was. My hypo was he clean shaven? He was described as being clean shaven. Okay, can they use a picture if it shows him with a beard?
They can, but it also depends on the other pictures
And
that
so
are
then
shown.
does every other picture also need to include a beard, even though the perpetrator was described as not having a beard?
Well, I think the type of feature also matters here. I think that's a variable that the court needs to account for. We're not talking.
All right, so can you give me some legal guidance on this? Like some case, are there any cases that tell us, you know, do you need to match, do the pictures that you put in the array need to match as closely as possible the description, or as closely as possible to the photo of the suspect, even if the photo of the suspect differs in material respects from the description of the perpetrator?
I would say that ultimately we're talking about making sure that the suspect does not unfairly stand out. That is the constitutional requirement. In Commonwealth versus Thornley, which is, I think, the most appropriate case here and the strongest case, we were talking about a photo array where only one individual had glasses. And that was a major issue given the description of the witnesses. Now, in that case, the court didn't say, well, you know, the police were required to draw glasses on every photo, but the fact that Mr. Thornley was exhibited as the only person wearing glasses made it unnecessarily suggestive. So I think there's two issues here. One is the type of feature we're talking about. Shaving can easily change somebody's appearance. I don't think facial hair is a type of feature unless it is critically relevant to the witness's description that really is going to yield the unnecessary suggestion that requires suppression. The thing here also is, when we're talking about unnecessary suggestion.
What about the tattoos? If, let's say the person describes the suspect as having a tattoo of a dragon, and the police have a photo of a person that for other reasons they think is a suspect, and it has and the person has a tattoo, but it's of a flower. Can they use that? And if they do, does everyone else in the array need to have a tattoo of what? A dragon? A flower? I'm just trying to figure out.
I think ultimately, Your Honor, the identification isn't of the tattoo. The identification is of somebody's face. So the easiest way to do this, because we're talking about tests and eliminating variables that could potentially affect the results. Easiest way to do this is to conceal the tattoos, because whether or not it's a flower or a dragon, if the witness has an accurate memory of what the perpetrator looks like, they can focus on the face and make an identification. And most likely, if the police follow Silva Santiago protocols, the witness would look at that individual who has the flower tattoo instead of the dragon tattoo and not identify them. That's
Okay,
what's
so what I hear you essentially arguing for, and I'd like to explore this. And let's say that we agree that the police did not conduct this array properly. Okay, let's say that we agree with that they should have put, either covered up what could be seen of these tattoos, or they should have, drawn in tattoos on everyone else, something, or picked people who had tattoos, whatever. Let's just say that we think that they did not conduct this array properly. Isn't there still a component where we need to determine whether the resulting array was unduly suggestive?
Well, I think the SJC disapproves of photo array where somebody's unfairly singled out. And
right. So what you said is unfairly. So how do we determine that?
well, I think the case law is pretty clear, because you look at a case like Thornley. Thornley is a situation where the glasses were a major issue in the case. And then you look at more recent cases like Marrero, where somebody was distinguished by a red shirt, I believe, and that wasn't even relevant to the witness's description because the witness didn't see somebody wearing a red shirt or possibly saw somebody without a shirt. So I think it's how distinctive is this feature? Is it a gray shirt like in Arzola, which really isn't that distinctive, or is it a tattoo? And the other thing is, how relevant is it to the eyewitness's description? And in this case, it was an issue. The officer recognized it was an
balance
issue.
that? So how do we incorporate, do we also evaluate, for example, the description that he had a black scruffy beard and that was missing?
Well, again, the warnings compensate for that. And we're talking about less distinctive features than tattoos, which are more enduring than facial hair. I could come in with a beard and I could come in shaved, but ultimately photo arrays are tests of somebody's recollection of a face. And
So
they can look at a face.
So when we know, sorry to interrupt you, that the tattoos as shown in the photo used in the array are very different than the tattoos the defendant had at the time he was arrested. Can we take that into account? Does knowing that make the photo that was used less suggestive?
I don't think it does. And I don't think we should be taking it into account. In Commonwealth versus Johnson, Massachusetts departed from the federal standard. We don't allow photo arrays that are unnecessarily suggestive to be admitted simply because we think they might be reliable. What Article 12 is designed to do is ensure and deter police misconduct and ensure adherence to Silva Santiago. So I don't think the tattoos matter. Moreover, the witness here didn't, and this gets into the second part about independent source, the witness didn't give any specific detail about the tattoos, consistent with a limited and poor opportunity to observe the assailant. So, there was no specific tattoo that was given. Moreover, had there been a specific tattoo image that was given, such as the dragon that Your Honor cited before, ultimately the policies say, this is the police. I'm not asking them to do anything that's not easily within their capabilities. Their own policies, which are designed to avoid misidentification, say, when the suspect has a distinctive feature, conceal or add it to make sure he doesn't unfairly stand out. That's not me. That's the Fall River Police Department. And there's a case, Commonwealth versus Summers, which we included, where a photo array was upheld. We wouldn't be here if the officer had just essentially concealed the tattoos and hadn't said anything about the cell phone being retrieved which is akin to Commonwealth versus Moon, the unfair special element of suggestiveness, we wouldn't be here. And that's the point. These photo arrays about fairness and due process. It's
Your
about
brother,
making
though,
sure.
relies on Arzola on the question of the similarity of the photos. What do you say about that case, about Arzola in particular?
Well, I think Arzola is in a distinctive feature. It's a gray sweatshirt, which is ubiquitous. I think here when you're talking about neck tattoos, you know, the witness said that when
But Arzola talks about hair length, skin complexion, age, and physical build. That's more than a sweatshirt.
That's correct, but the witness actually explained the basis of his identification. Here we just had that's him. There was no confidence statement that was taken, which is in violation of Silva Santiago. So we don't have any idea why the witness picked Mr. PLOUDE, other than the obvious, which was he was told the perpetrator would be in the array, and the only person who was in the array who had neck tattoos was Mr. PLOUDE.
Can you turn a little bit to your argument about independent source?
You can answer the question.
Thank you. I think it's clear, Your Honor, that the Commonwealth has been on notice since the very day that this motion to suppress was filed, that we were arguing that there was no source that was wholly independent of this tainted photo array procedure. Yet in their opposition, they didn't mention it. At the hearing in the motion to suppress, they didn't argue it. At this point, they've effectively waived it. Commonwealth versus a juvenile is pretty clear. If the Commonwealth doesn't call the eyewitness to establish the independent source, they can't argue that. And moreover, the evidence in the record, when you're looking at it through the principles of Commonwealth versus Gomes, the scientifically accepted principles on eyewitness identification, shows that this individual didn't have a good opportunity, and suggestion played into account here. And moreover, we can't encourage police to be as suggestive as possible with the hopes that somehow if the initial identification gets excluded, they still can have an independent source. And moreover, the last thing I would say is in New Mexico, they've already recognized the science. The independent source doesn't exist. Commonwealth versus Johnson, if an individual can't make an identification in court when they haven't been previously, a procedure hasn't been attempted, why would we let an individual who's been exposed to a suggestive identification make an identification in court as well? The bottom line is the Commonwealth waived the issue. There's no evidence to support an independent source in any case, and frankly, scientifically, it doesn't exist. Your Honors,
your time has expired, but if there's any further questions, I want to. No?
Thank you, Your Honors. I just ask that you reverse the judge's decision on the motion to suppress. Thank you.
Thank you very much. We will hear next from Attorney Walsh. You're on mute, Attorney Walsh.
Yes, thank you, Your Honor. Good morning, Your Honor. Dan Walsh for the Commonwealth. May it please the court. The Commonwealth requests that this court uphold the lower court's ruling denying the motion to suppress, finding that the photo array compilation was not unduly suggestive. Additionally, that the statement by the officer, although not better left unsaid, was not so prejudicial as to make the photo array unconstitutional. Your Honors have the photo array that was shown to the witness. The photo array was shown in black and white. There are other individuals in the photo array of similar complexion, size, hairstyling. I would suggest, Your Honor, that the photos of the 7 fillers and the witness in this case, the defendant in this case, are sufficiently similar, despite any markings around the neck of the defendant in this case.
What is the what is the legal standard you're using for that proposition?
That the
we just take a look and look ourselves and say, oh, sufficiently similar, or oh, not sufficiently similar?
I would suggest, Your Honor, that the trial judge review the photo array, and he is the finder of fact here. However,
But that's not a fact. Whether they're sufficiently similar would be a legal standard.
I agree, Your Honor. I would suggest that the case, I think Commonwealth versus Tremblay says that the court, and Silva Santiago itself says the court in those cases reviewed the photo array and determined, can make the determination on its own. So
Make what determination?
whether the photos of the fillers as well as the defendant in this case are sufficiently similar to be not prejudicial to the defendant.
Oh, is the test prejudice?
It's whether they're sufficiently similar so they're not so unduly prejudicial. And
And where do you get that language from?
You're right. I believe that's in Melvin and most recently Santiago by the appeals court, that decision that just came out last week. I think it's in several of the cases addressing this issue.
I thought it was unnecessarily suggestive.
I'm sorry, Your Honor. Maybe I misspoke. That's what I meant to say. I apologize if I misspoke. I meant to say unnecessary.
Well, this is certainly unnecessarily suggestive, right?
But
Because it can be easily, you could have either covered the tattoos or I gather digitally or something, put tattoos on everybody else, and then it wouldn't have been suggestive at all, right?
Yes, Your Honor. I agree with my brother on that point. If the officer had done some cropping or added tattoos to the other individuals, that this wouldn't really even be an issue. So
why isn't that the end of the story?
Well, I would suggest, Your Honor, that the photographs need to be viewed to see if it's so unnecessarily suggestive that it's prejudicial. So just that this.
But it's a question of how unusual, isn't it? It is for someone to get neck tattoos, right? I mean, if someone had 1 day stubble, men get that all the time, right? So maybe half the pictures have it and half don't. And oh, when I saw him, he had 1 day, he hadn't shaved in at least a day or whatever. We're not going to say the absence of a little bit of stubble or something means, well, these couldn't be the same guy. But there's, not everybody crosses that neck tattoo line, and goes out and gets neck tattoos. And one of the guys in the photograph had clearly already done that before the pictures were taken.
Yes, Your Honor. I'm not going to dispute that. Clearly, but I would say that the other individuals in the photograph
they could have gone out and gotten neck tattoos later, of course.
They could have, but I suggest that in the other photographs, the shading and the turning and the way the portrait is taken, so to speak, that it obscures the neck area on some of the other individuals, as well as having scruff in those areas. So I would suggest that that obscures the area, making them more similar to Mr. PLOUDE's photograph in the array. I would also suggest that
Can I just back up for a second? I guess I'm struggling with, in response to Justice Wolohojian's question, you said unnecessarily suggestive, and I see that in Melvin, and I see that in a bunch of the cases that you cite, Simmons on 18 and 19. But then in response to Justice Rubin, you said so unnecessarily suggestive. So I'm struggling with as you were asked earlier, what the legal standard is.
Your Honor, I suggest that it's so unnecessarily suggestive, and honestly, at the moment, I can't find where that term "so is" in the which case cites that. But I suggest that that is the standard that the court has had in the cases dealing with photo arrays of this nature that are have a feature that is dissimilar from the other individuals, or just to view the photo arrays in their entirety.
Do you agree that the question of independent source was raised at the motion to suppress?
I would agree it was raised in the motion filed by my brother. So in the motion that he filed, he did
Say
discuss
that there was no independent source.
that there was no independent source. Correct. I suggested
And do you think that Commonwealth v. Juvenile means that you've had your bite at that apple?
I would suggest not, Your Honor. It's my position that the initial burden is on the defendant for a motion to suppress a statement, excuse me, not a statement, a motion to suppress an identification. And once that statement is, once that identification is suppressed, or once that is allowed, and the burden has shifted back to the Commonwealth, there should be a second hearing about whether there is an independent source, almost similar to a Frank's hearing or something like that, where there's initial burden met by the defendant, and then it's upon the Commonwealth to do something additional after that. So there's no magic moment when the all of a sudden the burden has shifted and the Commonwealth needs to address it with evidence or what have you. So I would suggest that the Commonwealth has not waived that. In response to the statement by the officer, I would suggest, Your Honor, that would have been better left unsaid. But as the other cases say, Watson and Melvin say, commonsensically, the person knows they're going to be looking for a photo array for a reason. And so the fact that he said that essentially that a suspect is in, or a person is in the photo array does not taint the photo array. If there are no further questions, I would just rest on my brief.
I see no further questions. I'm a little surprised by that. Thank you very much, both. Excellent arguments on both of your behalfs.